Curious times in Abuja. Something just dropped today that's left many in the courtroom and beyond jaws dropped. Reports are swirling on social media and some newscasts claiming judges panic. Nnamdi Kanu drops bombshell in court today. As a journalist on ground watching developments closely, here's what we know and what remains unclear about the drama surrounding that headline. From verified public sources, Kanu is still at the center of a high-stakes trial at the Federal High Court, Abuja, presided over by James Omotosho. The judge recently scheduled a judgment date for the 20th of November 2025 after the defense failed to present its case. But Kanu's lawyers promptly filed a motion to stop the judgment, arguing that the charges are based on a repealed law. Legal minds, including his defense, insist this could nullify the entire trial. They argue that because the original statute under which Kanu was charged, the Terrorism Prevention Amendment Act 2013, has since been repealed, no valid conviction can arise from it. So what might the bombshell refer to? Several possibilities. It may refer to the fresh motion by Kanu asking the court not to deliver its November 20th judgment. That alone has stirred courtroom tension and public chatter. It could point to new legal arguments or evidence reportedly submitted by his team, though I found no credible public confirmation of any dramatic new evidence today. Or it might simply be sensationalism, headlines aiming to grab attention before real developments. Here's why many observers remain uneasy. If the court ignores the repeal of law argument and proceeds, it risks convicting someone under a statute that's no longer valid, a major blow to legal principles and a possible miscarriage of justice. On the other hand, dropping or voiding the case could reignite political and social tensions, especially given the wide support Kanu still commands among parts of the public. Meanwhile, advocates, community leaders, and legal experts are watching. Some believe Kanu might get off on technicality. Others warn such an outcome could set dangerous precedents or further polarize the nation. From the latest filings, Kanu has formally asked the court to arrest judgment, that is, stop the planned November 20, 2025 ruling, on the basis that the trial has been conducted under what he says are repealed or non-existent laws. His legal team insists this is not drama but a recognized legal procedure meant to prevent a verdict that could be void for lack of jurisdiction. They argue the court ignored a prior decision by the apex court on one of the counts and failed to take judicial notice of the repeal of the 2013 terrorism prevention law, a lapse they say strikes at the root of the case. On the other hand, the prosecution and the presiding judge James Omotosho seem to be pushing ahead. After the defendant refused to open his defense, even after several warnings, the court fixed November 20th for judgment. But tension remains high. Supporters of Kanu, parts of the public and some community groups, notably from the southeastern region, are calling for calm, arguing that rushing to judgment without resolving these legal questions could inflame unrest. Now, why is all this being framed as judges panic? Because from the outside the perception is that Kanu's motion and the legal technicalities he's raising have forced the judiciary to balance between delivering a verdict and avoiding legal backlash, where a wrong move could undermine judicial credibility. And that's what makes this moment critical. This is not just about one man's fate, but about constitutional order, the validity of charges, the integrity of our legal system, and national stability. One possibility is that the court, Federal High Court, Abuja, accedes to Kanu's motion to arrest judgment, meaning the scheduled November 20th verdict is postponed, and the court first hears and rules on the legal objections he raised. In that case, it could lead to the trial being declared a nullity, because as argued by his defense, the charges were based on a statute that has since been repealed. All previous proceedings and the plea he entered could be set aside. That would reset everything, and possibly force a recharging under valid law if at all, or complete dismissal of the case. Alternatively, if the court disregards the motion and proceeds with judgment as originally scheduled, the verdict could spark major legal and societal fallout. Legal experts already argue that convicting someone under a repealed law would violate the Constitution, making the conviction a legal nullity. Civil rights advocates and parts of the public, especially supporters of Kanu's movement, may view a verdict under those circumstances as illegitimate, risking protests, unrest, or claims that the judicial system has overstepped. Second, reactions and what's already happening. A human rights lawyer has publicly labeled any possible conviction under the old law unconstitutional, stressing that Nigeria's constitution forbids convicting someone where the offense isn't defined in a law that's currently in force. In the southeast and among supporters of indigenous people of Biafra, IPOB, there is growing concern that a rushed or flawed verdict will deepen mistrust, worsen tensions, and polarize opinions. Meanwhile, some in government and security circles likely view any verdict, even controversial, as necessary for national stability and deterrence, given the serious charges of terrorism and secession associated with Kanu's movement. Third, what to watch closely in the coming days: whether the court grants a hearing on the motion to arrest judgment, and whether that hearing occurs before November 20th judgment date or after. That scheduling decision could largely define the outcome. The response of civil society groups, human rights organizations, and regional leaders, especially from the southeast if the court moves ahead. Their reaction could determine whether tensions remain legal, constitutional, or escalate into widespread unrest. The tone from government officials, whether the executive arm or security agencies comment publicly, and whether there are calls for political resolution, pardon, dialogue, or insistence on strict enforcement. How the media frames the process, if the narrative remains legal technical, or if it becomes politicized, tribalized, or sensationalized. Finally, why this matters for all Nigerians: because this case isn't just about one individual. It pits fundamental principles: supremacy of the Constitution, rule of law, fair hearing against political and security interests. If courts are allowed to convict under repealed laws, it weakens legal certainty and could endanger the rights of any citizen accused of any crime. On the other hand, if perceived injustice or unfairness sparks social unrest, national unity and stability could be threatened, especially in a country like ours, with diverse ethnic, regional, religious identities. So this isn't just a court case. It's a test of Nigeria's legal integrity, institutional credibility, and national cohesion.